The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross of IJ's Center for Judicial Engagement, joined today by IJ attorneys Diana Simpson and Jeffrey Redfern. We'll start things off in the Court of Appeals for the Armed Forces. Diana.
So we have here one of the most fascinating cases I have ever read, and I have not read really any cases from the Court of Appeals for the Armed Forces before, but this one has to be the dooziest of the doozies. So basically, a 27-year-old Army sergeant was convicted back in the 1980s of a grisly rape and triple murder, and then he was sentenced to death. And so the people that he was convicted of murdering were the wife and two of three children of an Air Force officer. And so he was convicted and sentenced to death. But then the North Carolina State Supreme Court overturned that conviction because the prosecutors relied heavily on these particularly gruesome photos throughout the trial. And so these photos showed how each person was murdered, and then they put the photos above the defendant's head during the trial. And the defendant had stipulated that the people were murdered by stabbing, but they continued to use the pictures anyway.
So why is it a problem to use particularly gruesome photos?
It incites the jury in a particularly bad way. But so it leads to a more emotional response from a jury rather than a reasoned stance, which is generally the preferred method of conviction. So they send it back for a new trial, and he is acquitted at a new trial based on a bunch of kind of circumstantial evidence suggesting that he is not actually the murderer. So after he's acquitted, he re-enlists in the Army, serves for many years, and then he retires from the Army in the mid-2000s. But then a cold case review tests previously untested sperm samples from one of the victims, and they discover that this man, Mr. Hennis, is a match. However, because he's been convicted and then acquitted, the state can't try him again because of double jeopardy. And so does this mean he gets to go free? No. The military steps back in and recalls him to active duty, which is a thing that they can do for even retired service members. They court-martial him, and they sentence him to death. He's convicted and sentenced to death. And so in the course of this case, obviously, he files a slew of procedural motions with a bunch of different courts, with the military courts, with the standard federal courts, trying to get someone to pay attention to the fact that he's already been acquitted of this crime and he's being tried again for a crime that happened a long time ago that he contends he did not commit. But ultimately, none of those courts step in, and so he is convicted, and the Court of Appeals for the Armed Forces in this decision upholds that conviction and goes through a series of jurisdictional and substantive hurdles that he tries to establish that stand in the way of his conviction, but they affirm his conviction and his death sentence.
Jeff, any thoughts?
Yeah, so this is a case where I guess we have the two-sovereign rule, they call it. So normally you can't be tried twice for the same crime, but if you're tried by different sovereigns for the same crime, then that's okay. And because states and the federal government are technically different sovereignties, you can be tried in state court and also in federal court. Now, typically, federal prosecutors don't bring charges when people have been acquitted of the same crimes in state court. But that's just a matter of policy, and there's an internal review process. And essentially, if a federal prosecutor wants to bring a case against somebody who's been acquitted in state court, they have to go to main justice, and they have to explain that this is a really compelling case and get approval to do it. And it's supposed to only be in exceptional circumstances. Now, normally, it's going to be somebody who is really dangerous. If you've got an active gang that is still hurting people, then the federal government considers it urgent to get these people off the street. What's interesting about this case is that as grisly as these murders were, and they were really, really bad, it does seem like this defendant lived a pretty exemplary life afterwards. He got fantastic reviews from his superiors. He's a dad. He's a scout leader. It seems like everyone who knew him thought he was great, and that he's not the kind of guy who's going around continuing to hurt people. So in that regard, this seems like a slightly different case from the usual second prosecution by the federal government.
Diana, so what are some of the issues that the Court of Appeals for the Armed Forces delves into in this most recent opinion?
Well, so one of the things they go through is who can actually charge him and who can hear this criminal case, because the North Carolina state courts are now completely barred from hearing this case because of double jeopardy. The normal federal courts can't hear it either because what he did or what he's been accused of doing was not illegal under federal law. And so you can't charge someone in a standard federal court for conduct that is not federally illegal. And so all that
We'll back up. Hold on. Explain that. So murder and rape's not illegal?
Not under federal law. There has to be a particular federal hook for it to be illegal under federal law. So like terrorism, for example, murders committed by terrorism are illegal under federal law, but just standard murder that doesn't involve, crossing state lines or anything like that is typically not illegal under federal law. That's a true state kind of crime.
So those kinds of prosecutions are reserved for the states?
Typically, yes.
Unless Congress says this is now federally illegal.
Yes. And so really that just leaves the military courts to kind of rule over this. And is this a sufficiently military-related crime? And so the court says yes, that one, he was in the military when he was when the murders occurred, and two, that it was sufficiently connected to the military because the victims were related to other military members. And so the woman who was raped and murdered and then the two young children who were murdered were the dependents of an Air Force officer. And so, regardless of any of the other connections, the court says that that's sufficient, that you don't have to meet this really extensive 12-factor test that used to be the case, that all you have to do is just have this kind of status relationship between the military and the crime that was committed. And he checks that box. And so he is he's convicted and he is sentenced to a dishonorable discharge, forfeiture of all pay and allowances, reduction to the grade of E1, and to be put to death, which is quite the collection of sentences.
So, Diana, in addition to these jurisdictional issues, there are also substantive issues, which are namely the reasons why he wasn't reconvicted in his second trial in the 80s. There are all these conflicting circumstantial evidences. For instance, there's a bloody footprint that's way too small and couldn't have matched.
Right. And so this man was, he was convicted the first time, and on retrial they said, you know what, there is reasonable doubt and we're not sure that this guy committed these crimes. And so in his, I guess, third trial for these murders, he's not able to present all of the evidence that he wants. And so his primary argument here is that he was denied an opportunity to present his defense because he was not able to kind of pin it on the neighbor. His theory is that the victim's neighbor is the one who likely committed the crimes, and so they should call the victim's neighbor to the stand. They should call the neighbor's then girlfriend to the stand, and they should also call the neighbor's then roommate to the stand because the defendant in this case thinks that these bits of evidence are going to combine to create reasonable doubt that the defendant didn't commit this murder. But the court rejects it and then goes through some voir dire concerns that the defendant has and ultimately affirms the sentence, the conviction and the sentence. And so, from here, I guess they could take it up to SCOTUS if the high court is interested in it, but we'll see.
Do you think they will be?
Were I to bet, I would say perhaps, because I think this is actually a very interesting jurisdictional question. And I know that the High Court is interested in those kinds of questions, but they did not that long ago hear a case about these dual sovereignty issues. And so I'm not sure that they would be breaking new ground. So you never know. But I think this is probably a slightly higher chance than a standard case of getting heard.
Okay, Jeff, let's move on to the next case, which comes out of the Fourth Circuit.
Okay, this case is called Roe v. Department of Defense. This is a case about two members of the United States Air Force who were discharged because they were HIV positive. Now, the Air Force had determined that their chronic illness made them unable to deploy. So they sued in federal district court and got a preliminary injunction so they could remain on active duty while the case proceeded. And as is often the case, when you get a preliminary injunction, the writing is frequently on the wall about getting your permanent injunction at the end of the case. It looks like it would be very difficult for the government to win this case going forward based on what the Fourth Circuit said. So the district court initially held that the discharges violated the Administrative Procedure Act because they were arbitrary and capricious, and they violated the 14th Amendment's guarantee of equal protection. The Fourth Circuit affirmed on APA grounds only, not reaching the equal protection claim. And it goes on for pages and pages discussing the history of HIV, the treatments that have been developed, and the court says the record shows that HIV patients, and these plaintiffs in particular, only have to take a single pill per day in order to keep their HIV at undetectable levels. These pills are not subject to special storage requirements, and even if an infected person stops taking them, it takes a long time for the virus to build up to detectable levels again. Additionally, the court noted the risk of infection from even untreated HIV patients is pretty low, and it's essentially zero for somebody who's taking their medication. So in light of all this, the court concluded that it was arbitrary and capricious to discharge these airmen. Now, the government didn't really have an answer for any of this. Basically, it said, we've determined that the illness is a problem and you have to defer to us. They also threw out some pretty absurd hypotheticals, like the idea of, quote, battlefield transmission of HIV, which they didn't really explain, but I imagine it means something like if one of these HIV-positive airmen is wounded, he'll be spraying blood around and other people will get infected. Now, I have some friends who have infantry experience, and I think they would laugh at the idea of airmen being in a pitched battle on the ground. But of course, even if he were in a situation like this, the court pointed out that all the science indicates that there is still essentially zero risk of getting an infection from somebody that way. Now, this was a case decided under the APA, which means that the court is not supposed to substitute its own judgment for that of the agency. In this case, the agency is the Air Force. The Air Force only gets reversed if its decision is arbitrary and capricious. So basically, it can't be contrary to all the evidence, and they can't fail to grapple with important parts of the problem. But as long as it considers the relevant evidence, its reasonable decisions don't get reversed. So it's normally pretty unusual for agencies to lose APA cases. Now, for me, one of the big takeaways of this case is that the government bothered to litigate at all, though, because the evidence here is just so one-sided, and the government's arguments are just so weak. I feel for the line attorney who had to stand up and make these arguments for the government, just knowing that there was a good chance he was going to get creamed in court. But the truth is, this wasn't necessarily a slam dunk case for the plaintiffs, because you can't take for granted that you will draw a panel that's really willing to look at the evidence. If the government had drawn a different panel, this might have been a 3-page decision saying, essentially, the military is entitled to deference. We can't second-guess their decision. There are all kinds of problems that could happen, and we are not in a position to say that they aren't serious. But fortunately for these plaintiffs, that's not the panel they drew. One other interesting aspect of this case is that we get a little discussion of national injunctions at the end. This has been a really controversial issue in the last few years. The question whether a single federal trial court can issue an injunction that binds the federal government everywhere across the country, even affecting people who were not litigants before the court in that case. Now, the district in this case issued an injunction that bound the Air Force with respect to everyone with HIV. The panel then said that the Supreme Court had held that these national injunctions are okay. That's not entirely accurate. What the Supreme Court has done is it declined to stay a nationwide injunction. But in doing so, the Supreme Court noted that stays are discretionary. So when you refuse to stay an injunction, it's not the same thing as saying that the injunction was properly granted in the first place. It just isn't so wrong that the court feels compelled to interfere. So we are still waiting on a definitive statement from the Supreme Court about nationwide injunctions, and I expect that issue is going to continue to be pretty hotly debated.
For sure, because the other side of the coin on nationwide injunctions is that if the federal government is violating someone's rights in the Eastern District of Virginia by discharging these servicemen for basically a disease that is not causing harm to other people, then it's just as illegal or unconstitutional, however the court ends up ruling, for them to do it in the Southern District of California, for example. And so it doesn't make a whole lot of sense for the federal government to be kind of doing this mishmash of enforcing its laws all over the country based on different courts doing different things. And so it seems to me, at least in this particular case, that a nationwide injunction was the right call.
Right. And as the Fourth Circuit noted, even though this is a nationwide injunction, it's actually a very narrow nationwide injunction because all it requires the Air Force to do is to make real evidence-based, individualized determinations. So if somebody is HIV positive and is not, responsive to these drugs or something and has other health issues, the result could be very different in that case, and they wouldn't be bound by this decision, except insofar as they are required to actually consider that evidence. But the court did not say that everyone with with an HIV positive diagnosis is required to remain in the Air Force no matter what or anything like that.
Right. And I think the narrowness of this is exemplified by a little paragraph they talk about on page 12, where they're saying that, this other organization that works on behalf of LGBTQ community and the HIV positive community has identified 4 other HIV positive Air Force service members who have been deemed unfit for duty and ordered discharged. And so that's on top of the 2 plaintiffs here. So you're talking about, a massive Air Force, and you're talking about 6 individuals. And so I'm certainly not denigrating their rights or anything like that, but this isn't going to cause this kind of upheaval that sometimes the government likes to warn about and get people to maybe be more deferential in their rulings.
Yeah, I think that's right.
Do either of you have a sense of why the issue of nationwide injunctions is coming up now? I mean, we've had a republic for quite a few years, and we've had district courts issuing different opinions on the same matter for many years, presumably before now. Why is this such a hot issue these days?
Politics. I mean, not to sound too glib about it, but this particular presidency has done a lot of really big sweeping rules and laws that they're trying to get passed, and people have been suing over a lot of them. And then, if you've got a nationwide law, you can kind of go and cherry pick a little bit to see where you think you'll have the most success, which court you'll have the most success in. And, traditionally, I think that conservatives have had more success in the Fifth Circuit, while traditionally perhaps liberals have had more success in the Ninth Circuit. And that's not to say that everything is either conservative or liberal. I think libertarians certainly disagree with that painting of things. But that's just kind of traditionally how it's been. And so litigants will then go to those particular circuits and get a ruling that perhaps may or may not reflect current case law and current thinking, or, another district court will disagree vehemently on a particular issue.
I think one of the reasons, I think there are several reasons it's becoming a bigger issue right now. One is just that these injunctions are objectively becoming more common than they used to be. I think there's also some strategic behavior on the part of some pretty sophisticated litigants who know the history of all the judges, not just in the circuit, but in every federal district. And some federal districts are quite small, so you can basically know, if you file here, you're going to get one of these couple judges. Sometimes you can even figure out, if you're trying to get a TRO, a temporary restraining order, you can figure out which judge is the one who's going to review that order based on the time of day you file it. So you know who's very likely to get your case in the end. But the flip side of it is I think you're seeing more resistance on the part of the government to changing their behavior absent a Supreme Court ruling. I think it used to be far more common that if you get a district court or certainly a circuit court ruling against you and you're the government, your expectation is that, okay, we're going to stop doing this and then we will appeal it up to the Supreme Court. And now I think that we're seeing more resistance, the government more willing to push to continue enforcing its policies until the very last minute when it really doesn't have an option to anymore. So there's pressure on both sides.
Okay. And with that, let's move on to the next case, which comes out of the District Court of Arizona. Diana?
This is a wild case. And so this is basically about religious activity and philosophical activity and helping immigrants. And so there's all kinds of politics and religion and all the things that you're not supposed to talk about at dinner tables. But this case is definitely something to talk about at the dinner table, I think. So this case involves a court reviewing the convictions for violating particular regulations about the Cabeza Prieta National Wildlife Refuge in southern Arizona. So these 4 individuals were basically convicted of a few regulatory violations related to their leaving supplies of food and water in the desert, where people are frequently dying of dehydration and exposure as they're making their way up through the Mexican border into the United States. The individuals at issue are part of a charitable organization, and it is affiliated with the Unitarian Universalist Church, which becomes pretty important later. So basically, they entered this area, the refuge, without a permit. They drove on a restricted access road. They didn't have a permit. They left food and water for those in need to find. They did this with the goal of mitigating death and suffering. They said that they did it because they were motivated by their religious intent, and that this prosecution that the federal government is going after is barred by the Religious Freedom Restoration Act, or RFRA. And so the court kind of goes through exactly what happened and then goes through RFRA quite a bit. And it is really, really fascinating to me, kind of figuring out the moral and the ethical implications of all of this involved. And so these people basically went onto federal land and they left food and water, just very basic supplies for people who are at significant risk of death. I mean, there were nearly 3,000 bodies or remains found in a 17-year period in this area. And so this is a particularly dangerous part of the border crossing. So people... It's very hot. If you've ever been to Arizona, you know that it's pretty hot. They're doing this in August. They left all this stuff when it was over 100 degrees. And the reason that they were violating the law was because visitors are required to get permits before they enter this particular refuge. And they're required to enter a hold harmless agreement with the government that basically describes the refuge as one of the most extreme environments in North America and warns that there are no sources of safe drinking water in it. And so right before these folks went in to leave the food and water, the permit application to enter the space was amended to specifically prohibit the leaving of water, food, blankets, clothing, and medical supplies, because lots of people are doing this right now. They see themselves as having a moral or perhaps religious obligation to leave these things for folks, and the federal government does not want them to do that because they think it is essentially encouraging immigration, illegal immigration. And so these folks were convicted on entering without a permit, abandoning property, and then one was convicted for driving in a wilderness area in violation of a particular federal regulation. And so the District of Arizona goes through the convictions and goes through RFRA and finds that RFRA completely blocks the convictions here.
Okay, a little background on RFRA here. What RFRA does is it establishes a strict scrutiny test for government actions that violate religious exercise. Now, what that means is that religious people or people who are acting on the basis of their religious faith are going to get exemptions from otherwise neutral laws that are not specifically targeting religion. They're not trying to ban church services or anything like that. But if if your religion requires you to do something that happens to be illegal, then there's basically a presumption that you get to do it unless the government can prove that prohibiting it is the least restrictive means of advancing a compelling government interest. And that's a tough test for the government to meet. Now, what I think is really interesting about this case is that a lot of RFRA cases we see, the only burden on the government, the only reason the government doesn't want to grant the exemption is because it's going to be a little bit more complicated or expensive for the government to do so. Sometimes it's just an administrative burden. Sometimes the expense could be real. So like in the Hobby Lobby case, one of the arguments was that the government can't force religious employers to provide contraception in violation of their beliefs because the government can just as easily provide the contraception itself. It's just, the cost of the contraception. Here, though, the religious people are claiming that they have a right to essentially try to undermine a government policy. Now, what's interesting here is that the court doesn't really take seriously the government's policy of forcing migrants to die in the desert. But it would be, I think, a much harder case if, for example, you had people who said they had a religious reason to cut holes in border fences or something, because then they are really going against a sort of legitimate government policy that most people recognize the government has the right to do. Here, it seems like the government was a little wishy-washy in making a full-throated defense of its "let's force people to die in the desert" policy for understandable reasons, because it's pretty horrifying.
One of the interesting aspects of the case and of RFRA generally is that RFRA is designed only to protect religion and not necessarily philosophical viewpoints. And so that makes it a pretty controversial law in some corners, because why is religion protected in a way that deeply held philosophical beliefs aren't? And the government kind of goes after that a little bit in this case, saying that these particular defendants aren't sufficiently religious, that they're associated with this organization called No More Deaths, that is associated itself with the Unitarian Church, right? Is that what I said?
Unitarian Universalist.
The Unitarian Universalist Church. My apologies. And so then the court goes through what qualifies as religion, what is a sufficiently held belief to kind of meet that pretty steep burden. And that's also kind of terrifying, that the government is going to sit there and that a judge is going to decide what is a sufficiently held religious belief as opposed to just a philosophical belief. And that just kind of icks me out a lot, because I don't feel that that's an appropriate role for the government to play. But I recognize the situation that they're in is because the way RFRA is written and what it was intended to do by providing these religious exemptions to otherwise neutrally applicable laws. I think to talk about Jeff's example a little bit about, what if their religion required them to go cut a hole in the fence? Maybe the religion itself wouldn't be what was motivating that, because in this particular example, the defendant said that, they're helping people according to particular scripture that says, you have to help the least among us. And so they aren't necessarily perhaps they're helping them in a different way if they are cutting a hole in the fence, as opposed to leaving just really basic humanitarian supplies to help people not die. There are a ton of people dying in this desert, and that is a humanitarian crisis itself.
And for the most part, I think courts are sensitive to the fact that it's not really a good look for courts to be looking too closely at whether your beliefs are really sincere religious beliefs. For the most part, they're willing to take people's words for it. I think in this case, the court cited a few examples of cases where religious freedom defenses failed, and they were, pretty obvious pretexts. But I do think that the upshot is that if you have a strongly held philosophical belief and you have a decent lawyer, it's probably not going to be that hard for you to portray that as religious or at least, connected to some larger faith about the universe. And maybe that's the way it should be. I don't think that Congress necessarily had in mind all philosophical beliefs, but unless you're going to have courts getting into the business of making really fine distinctions about what's faith and what's just your conscience, I don't really see a way around that.
Yeah, I mean, it's a thorny issue. If an atheist did the exact same thing, their conviction gets upheld, right?
Well, maybe. I mean, is atheism a religion or is it a lack of religion? I don't know. Now we're into philosophical questions, and now we're into an even deeper thicket. I will say that the prosecutors have appealed this. They filed the notice of appeal to the Ninth Circuit. So perhaps I take a harsher approach to viewing the intent of the government attorneys, a slightly harsher approach than Jeff does. I don't feel bad for the line attorneys here. I think that they are, this entire prosecution is pretty immoral. I think that continuing down this road is a ridiculous position for the government to take in a land of limited resources and prosecutorial discretion.
Just to be clear, this wasn't the case where I felt bad for the line attorneys.
Right. And not to put you on the spot.
I'm on your side here.
You should still feel bad, though, for something else, if not this.
Nah. The prosecutors should feel bad about this.
Okay, and with that concludes the show. Thanks for listening. Until next time, this is John Ross from the Institute for Justice, encouraging you to get engaged.